The Vermont Eviction Notice. What is an eviction notice? Eviction notice, or notice to quit, is a letter sent by the landlord to the tenant notifying them that they should either take or stop a certain action or vacate the rented premises. Eviction notice can be of two types. Conditional, when a tenant is given time to remedy the breach of the lease, or unconditional, when a landlord terminates the lease without any alternative options for a tenant. What should an eviction notice include? Information about the tenant and the landlord. The reason for sending the notice. The date by which the tenant should take or stop a certain action. The consequences of non-compliance. The date and way of notice delivery and the landlord's signature in the form of certificate of service attached to the notice. How to evict a tenant in Vermont. Non-payment notice. There is no grace period set by Vermont law, which is why it should be addressed in a lease. But the state legislature requires the landlord to provide the tenant with a 14-day notice if they fail to pay rent on time. If the tenant fails to pay rent within the given period, the landlord can start an eviction process. Non-compliance notice. When it comes to other violations of the lease, the landlord in Vermont is not obliged to let the tenant correct the lease violation, but they are required to provide a 30-day notice to quit before they can file a claim with the court. If the tenant participated in illegal activity, the landlord needs to send the tenant a 14-day notice requiring them to move out. What if the tenant fails to comply? If the tenant fails to comply with the rules of the lease, the landlord can file a complaint with the Vermont Superior Court. It should be done within 60 days of the final date on the eviction notice sent to the tenant. The filing fee is $295 statewide. The tenant should get the complaint within 60 days of filing it with the court by a court-authorized person. Then they will have 21 days to file an answer with the court if they aim at contesting the eviction. The tenant's failure to file a response or appear for the hearing might result in a judgment in favor of the landlord by default. If the court rules in favor of the landlord, a writ of possession will be issued. However, the tenant has a chance to stop the eviction process by paying the past due rent, plus any interest and cost of suit before the writ is executed. If the landlord wins the case and the tenant does not pay the past due rent, the writ of possession posted on the rental unit will give the latter 14 days to move out. However, if the tenant is evicted for unlawful subletting, they will have only 5 days to leave the premises. The same applies to the case where the tenant violates the rent escrow order.